Mr. Jadala.
Sir.
Gentlemen, I understand we're here to talk about two things today. One, bond violation. One is bond violation, and two is there's going to be some dismissals on some files.
Yes.
Yeah.
Can we start with those?
Yes, we're ready to go.
Bring them.
Yeah.
And we're going to drop the charges without prejudice. Getting a call from Rocco Rossi saying they're bringing furies. That's why I keep sending you messages. No, resisting, obstructing, causing injury to police officers. And then the stalking is a misdemeanor. That's
Why don't we do it this way? Let Mr. Bright know that I've called the file, and if he doesn't come in, I'm going to issue a bench warrant for his arrest.
By the way, we're having a screening of Cape Fear at my house this evening. Would you like to join, Judge?
Oh, that is a good movie.
And then Pacific Heights.
Gentlemen, your appearances on the People versus Bright, please.
Yes, good afternoon, Your Honor. Michael Mulata, on behalf of the City of Lincoln Park.
Secretary, Your Honor, Sarah, 2186.
Thank you.
Appearing on behalf of
All right.
Brian Bright.
Thank you, Mr. Bright. All right, so go ahead.
So, Your Honor, I filed a motion for an order to show cause, and that's based on the fact that I'm sure the court recalls that when we were here last, the court released Mr. Bright from custody and on specific bond conditions.
I thought we were going to start with something else.
Oh, I'm sorry. Well, we are going to, there isn't going to be a motion to dismiss in the interest of justice, since Mr. Bright has felony charges that have already been bound over.
Okay.
So we'd like that be dismissed without prejudice in the case that we need to.
Is that all pending charges that are in this court?
In this court, yes.
Okay. Okay.
And we have no objections to this.
All right. So if you're going to motion to dismiss, do we have to have a bond violation discussion?
I wanted to bring it to the court's attention. I think it's serious, the fact that Mr. Bright has been emailing the mayor of the City of Lincoln Park after the court ordered him, as a condition of his release, not to have any email contact or any contact with these folks. In fact, he's emailed them. He's emailed the Mayor Higgins, back in May after the court gave its order,
Right.
as well as recently as yesterday, June 5th. He sends videos. He sends.
I think I also ordered a mental health evaluation as part of bond, didn't I?
Did.
Yes, Your Honor, and he did comply, Your Honor.
Did he?
He went to the guidance center, Your Honor, and the guidance center was going to provide him services, Your Honor. Mr. Bright was under the impression that it would probably be better off if he received assistance from the forensic center. And I said that's something that he needs to talk about with his felony attorney, because in this matter, competency wasn't an issue. There was a previous competency hearing.
I'd like to see the results of the evaluation.
Yeah. And Mr. Bright, did you do an evaluation at the guidance center?
Attorney advised me to stand. If you want to talk to me outside, sir, I would love to talk to you outside in privacy. You can have all the information to present to the judge.
And Your Honor, in pursuant to the bond violation, the bond violation was clearly that he was not to contact any city officials for non-business purposes. There is a pending current claim in the City of Lincoln Park, a claim that has not been into a lawsuit, but there is a pending claim. He was contacting the mayor this hours in order for him to discuss that claim. He understands that matters revolving this case aren't to be contacted, and any victims or anybody who's a part of this case should be contacted. He did email, he acknowledges emailing the mayor, but for business purposes, pursuant to a claim that has been filed civilly against the City of Lincoln Park. Your Honor, I'm handing this to your court officer. It's showing proof that he went to the guidance center and that he does have verification and such.
This shows he's got an appointment today.
That's what I see on the actual council.
It's rescheduled for Wednesday.
Okay, so this doesn't show that there was an evaluation done.
It's scheduled, sir. Psychiatric is.
So you didn't do what I told you to do.
It's scheduled for the 10th, sir.
I'll take that as a no. You didn't do what I told you to do.
How am I supposed to get a schedule? How am I supposed to schedule for them? They take care of the scheduling.
When did you contact Guidance Center, sir?
Immediately, Your Honor. We contacted him immediately after his release. His mother and him contacted me. We went to the guidance center. At first, they didn't want to comply. They wanted to know exactly what he was seeking it for. And so I advised him general mental health, a general mental health referral. And I believe this is what happened next time, where they gave him these to come in at 6:10 at 1 p.m. with Dr. J. And Your Honor, I have shown the prosecution the bond condition where it says that you only to contact for business purposes during business hours, which that's exactly what he was doing, attempting to contact the mayor regarding this claim and regarding the claim. And that's all we have to say about the bond condition. And again, we have no objection to dismissal.
When did I order the mental health evaluation? What date?
That would be, Your Honor, the mental health evaluation was ordered upon his release at his last court date, Your Honor. I don't have that date. Yeah. Yeah.
So April 25th.
Yep, when you asked him, Your Honor, to go to the guidance center within 2 weeks, which he did, and these were the dates that he was given after his visit to the guidance center.
Your Honor, as the victim, may I address the court?
What happened to the guidance and the paperwork I just had? Did I give you that guidance center report back?
Yes.
Your Honor,
Go ahead.
Your Honor, Mr. Zelenak would like to address the court based
Sure.
on his experience.
for Zelenak, Your Honor, I'm listed as the victim in this case. It needs to be addressed to the court that this was the same scenario, or what one might call a three-card Monte, when these charges were initially dismissed against Mr. Bright in the 28th District Court, and he was scheduled that day for emergency inpatient intake at the guidance center, which he failed to complete at that time also. And that's one of the reasons why the charges were filed, in addition to his continued preponderance in sending information to the city of Lincoln Park, sending the city attorney emails in the middle of the night, making references being gone within 7 days, which is the basis of the claim and the charge in the 36th District Court and the 3 felonies downtown. My concern would be, as the victim in this case, that we are exactly where we were in Southgate several months ago on the same charges with the same presentation, and Mr. Bright still has failed to go to the guidance center, which would get him in immediately based upon the preference he was given. So I'm not sure whether it's truthful or not, but the court should know that what he contacted the mayor with was a video of myself, me, the victim, at a city council meeting in 2008, at a city council meeting saying, would you take him as your witness? Would you support him as your witness? That appears to have nothing to do, at least in my opinion, as a victim, with his purported civil claim, which is just a series of correspondence between Mr. Bright and John Gillooly from the Garen Lukow firm in the Michigan Municipal League about a purported claim for $20 million against the city of Lincoln Park. If the court can draw that conclusion, then my position would be we are at a point that he did not violate the bond. But to me, that is a violation of the bond because he referenced me, the victim in this case, in his attempt to contact the mayor, and a second follow-up concerning some purported complaint he wants to file against the mother of his child on a destruction of property charge, which is beyond the ordinances in the city of Lincoln Park. It's a 2-year statute, and he'd have to go to the county prosecutor. And he's been sent down there on that. So
are you involved in the $20 million lawsuit in any way?
no, I'm not. Lawsuit. There's just a letter where he demands $20 million for being mistreated by the court and by the city.
Okay.
So there's no litigation. However, it was an email to Mayor Higgins that featured a video of a council meeting from 2008, where I was being addressed and addressing the council. So I fail to see as a victim how that has anything to do with this $20 million claim he has against the city of Lincoln Park. I just think it's warranted to point out to the court that we're at the same juncture, and I'm asking as the victim that these charges be dropped, not to burden the court because of the felony charges, but Mr. Bright, for all he professes to be a victim himself here or innocent, has manipulated the system again. We're right at the same point we were in front of Judge Mullins 3 to 4 months ago.
Except, Your Honor, that there are felony charges pending. They're hanging over.
That's true.
In Frank Murphy.
So
With their own separate bond conditions that he must abide by, and with their own separate things. And Your Honor, just a brief response. I understand Mr. Zelen's concern, but I just want you to understand the argument. The argument was that this video links him because it shows him. He wasn't contacted. He contacted someone, the mayor, who is per se a member to this claim that's been filed, showing him as a victim, but not contacting the victim. The no contact and the bond condition was not to contact any victims for non-business purposes. They weren't contacted. The mayor was contacted during business hours with his concerns.
And the video that he's referring to was sent prior to this case being initiated. So I don't, if you would compare emails, we could get to the bottom of it.
Well, here's my problem. Procedurally, if the cases are being dismissed, there's no reason talking about bond. I'm not going to enforce a bond on cases that are going to be dismissed. I mean, just,
That's why.
if you don't want to dismiss, then we'll talk about bond. But if you're going to dismiss, I don't think it makes any sense to talk about enforcing a bond on cases that are being dismissed.
I understand. I brought it to you as a criminal.
I understand that. I understand that.
That's why I did that way. Thank you.
So,
I don't want to talk to him.
Your Honor, make one further comment as the victim, because I cautioned Mr. Bright when previously the victims were the city of Lincoln Park and the 25th District Court, that if he continued the nonsense of emailing people, which he did to me, referencing family members, making threats requiring personal protection orders, threatening the court clerk in the 24th District Court, which presided over his previous criminal trial with the conviction, that if he did it again, we'd be right back here, and we are here again today. And I am comfortable as the victim in not only crossing these 3 charges, but other than non-institutional justice. Mr. Bright needs to learn a lesson that you go to the psychiatrist, you do what you're told to do by the court. I don't want to burden this court with enforcing that. There are different conditions downtown. I do not want to proceed as the purported victim in these cases. I'm asking the special city attorney to not only cross these matters, but Mr. Bright needs to hear this in plain English, and he needs to stop being babied or pansied by his parents or whatever his support group is to continue this conduct. What does it take to understand you don't put your fingers on a keypad, send emails to the mayor? It's all balderdash to claim that by sending the mayor a video of me from a council meeting 15 years ago or 16 years ago is relevant to this case or his claims against the city. And that's all I have to say. And I would ask this prosecutor to drop the charges today, Your Honor. And the court has addressed it properly, but Mr. Bright needs to hear that nonsense comes to an end at some point.
Yeah, so as far as what the court could do now, I believe the court has the inherent authority under the case that I cited in my brief to find, to hold the hearing and find him in contempt.
I agree with that. And then I can revoke his bond on cases that are being dismissed.
I understand.
It makes no sense to me. I mean, I agree 100%. He needs to hear something he hasn't heard yet.
Yeah.
But I don't think he can hear it.
I agree.
Which is why I wanted the mental health evaluation, and there's no doubt in my mind that he's playing games. All right. There's no legitimate reason to email the video to. I'm not asking questions of you, Mr. Bright. You're better off if you don't say another word while you're here.
Yes, sir.
Okay. I'll dismiss the cases. I'll accept the nollie cross, but I just don't see where it makes any sense for me, because if I enforce the bond, I'm revoking the bond. He's going to jail, and that makes no sense. He needs treatment, not jail.
Right. I totally agree. So I guess some of these issues will need to be addressed with the court that he's before now. The circuit court.
I hope they get addressed, because he's not going to just change his view of reality. Good luck downtown, Mr. Bright.
Thank you, Judge.
Thank you.
I can't.